May please, Your Lordship. Lord, the respondent is a CISF personnel, Your Lordship. And during the course of surprise inspection, the petitioner was found sleeping on the watchtower with his rifle, Your Lordship. And thereafter, show cause notices were issued against the petitioner, in which the petitioner has submitted, petitioner has replied, and thereafter, the disciplinary authority has have found the petitioner guilty, and it was directed to deduct 3 days' salary, 3 days' pays of the petitioner.
What is the punishment?
But initial, the disciplinary authority has imposed a punishment of 3 days salary cut. Thereafter, the petitioner has filed an appeal in which again they have found the charges to be proved, but they have reduced from 3 days to 2 days salary cut, Your Lordship. Against that order, the petitioner has filed a revision, and in the revision application was rejected, Your Lordship. Against that order, the petitioner has filed a writ application before this Honorable Court, Your Lordship. And in that writ application, basically he submitted that the deduction of pay, which is in fact a stigma and would become an impediment in future promotional as prospect of the petitioner, Your Lordship. But contra, Your Lordship, the CISF has submitted in the writ application that upon
Question only non-payment of pay for 2 days.
But only
For that writ petition.
for that writ petition, Your Lordship. And writ court too has found this punishment as suitable.
How they have affected this? Sort of punishment. Putting of pay. How would affect his service category?
They have taken
For such a tribal issue, why did you opt for filing LPA?
Lord, the main issue behind this fact that the Honorable Single Judge has held that they have admitted that it is an admitted position that petitioner, but instead of the petitioner, they have found that the petitioner was suffering from medical ailment and the petitioner ought to have taken leave, but instead he continued with his job, resulting in the aforesaid lapses on his part. Now they have held that which now the petitioner is precluded from challenging under the writ application. Now the only question is with regard to the quantum of punishment, which in my view, considered view, is not required to be interfered. But they have come to a finding at the end that the said order of punishment shall not be considered as stigma on the petitioner herein and would not create any impediment in future promotional prospect, my lord. This is the main issue, because this observation is creating an issue that against the DPC, it is against the DPC guideline, Your Lordship. In a DPC guideline in the promotion of CISF personnel, and the said observation will place this petitioner respondent in spite of having conviction above those persons who are having absolutely clean service record and which will lead to indiscipline and dissatisfaction in the paramilitary forces, Your Lordship. This
Which is the promotional post? Which is the promotional post?
promotional post is head constable, Your Lordship.
Where is the method of recruitment of head constable?
Not for the post of head.
No, for the head constable post, in
Fine.
the event of petitioner eligible, whether this 2 days absence will come in the way?
Lord, it is because it's a minor punishment, so only 3 marks.
Minor punishment.
Under
Under the discipline rules.
Yes, Your Lordship. Lord, may kindly come to the counter affidavit filed by the respondents here.
In the writ petition.
I mean, in the LPA.
The LCA, they have filed counter.
Aye.
In that, they have produced what?
They have annexed a copy of the manual for CISF, Your Lordship, legal manual 2017 for CISF, in which this issue has been discussed.
Where is the minor penalty?
It is relevant page is page, it starts from page number 5, annexure A. Annexure A, page 5, it starts with, and the relevant paragraph is at page number 13. At the bottom, Your Lordship may kindly see. The matter regarding the effect of censure and pay fine to any amount not exceeding 7 days' pay in promotion in ACP scheme has been examined by the Ministry of Home Affairs, MHA, in consultation with the Department of Personnel and Training, and it has been clarified that the DPC will take into account the aforesaid penalty while assessing the suitability of the government servant in promotion. If the DPC recommends for promotion, such employee would be promoted. In short, there will not be any currency for implementation of censure or by fine. So, Lord, here considering this punishment, there is no censure.
This punishment will not come in the way.
It will come, Your Lordship.
How?
Only 3 marks will be
No,
deducted.
sir. Not exceeding 7 days pay in promotion.
Yes,
Huh.
Lord,
Here it is earlier 3 days, now it has been reduced to 2 days.
2 days.
So 2 days will non-payment of any.
Lord, if there would have been any vote, then he will not, his promotional aspect will not be considered. But so far this, because it is below 7 days, so only 3 marks will be deducted.
Where is that 3 marks and a mark?
That I'll have to bring on record, Your Lordship.
This is a privilege, better withdraw this LPA.
Lord,
Better concentrate on some other case.
but
Sir, do you know?
because they,
Do you know recently Apex Court condoned the 100 days absence? That too in a matter of the military. A person remained 100 days absent, that has been condoned, and the penalty of dismissal has been modified to that of compulsory retirement.
this is definitely a different issue, Your Lordship. Here, he was found sleeping on the
What we
watchtower.
are saying is this is a tribal issue. For 2 days absence, you are filing LPA?
This is not an issue of 2 days or 1 day even. The main issue is because he is, the Lord, the petitioner is,
Have you held inquiry? Have you held inquiry?
yes, Your Lord.
Where is the inquiry report? Where is the charge memo?
Lord, for that you will have to come to the,
No, from the writ petition order,
Writ petition.
you point out.
Yes,
In
sir.
the penalty order, where is the reference to charge memo?
lenient view has already been taken, only
Where is the charge memo?
my Lord, I am coming to that one.
Didn't go to charges?
That memo is at page annexure 2.
No, where rule 36? Rule 36. 36 of CISF rules. No, this is manual because here it is. Special procedure when inquiry contemplated in the rule that is not reasonable price. This is guideline. This is the kind rules are there.
Lord, the charge against this petitioner is that on 8/8/2016 8/8/2016 को समय लगभग 8:13 बजे चेकिंग के दौरान बल सदस्य हथियार साइड में रखकर कुर्सी पर बैठकर सोता हुआ पाया गया। बल सदस्य द्वारा उपरोक्त कृत्य उसके कर्तव्य के प्रति लापरवाही एवं अनुशासनहीनता को दर्शाता है। अतः यह आरोप है।
Like this. Fine to any amount not exceeding 7 days pay. They are imposed under this clause. Now, try to follow this. Where is the charge number? Then whips. That is
Annexure 2 at page 25, Your Lordship.
deposit plan. Huh?
Annexure 2 at page 25 of the writ application.
Yes?
25.
Writ petition papers किधर है? These in turn. Doctor, this medical certificate and other things, is private doctor or your CIS?
Yes.
Huh?
Yes, sir. Office.
CIS, sir. Then all those doctors, clinical note and other documents, how it has been considered while passing the penalty order?
Lord, perhaps your lordship will see the
Admit. Treatment. Sorry, time gap from the date of discharge and the date of which incident is like. Second of July. Date of incident. How after these many days it has been. But he got was promoted. Whether his date of promotion was deferred in account of this. But he has been promoted on 7/1/2000.
no, my lord. My lord, may kindly see the annexure B. It's not promotion order, rather it is inter-C seniority list only.
Here,
Only.
In
No
head
promotion.
customer, in head customer. He is constable initially, now he is a head constable and annexure C is fine, एक minute.
Lord, may kindly come to annexure B at page 14. This is issue of provisional inter-C seniority list.
Whom?
Head constable inter
Head
seniority list है. अभी
Head
DPC होना.
list of head constables.
Yes. Senior.
Once his name is reflected in the head constable senior list, one has to draw inference that he was already promoted.
It is provisional inter-C seniority list.
Sir, provisional senior.
After
Are you saying that he has not been promoted? He is still holding the post of constable.
for that I have to file a reply to this one, Your Honor. Because I have to take instructions. We have already forwarded this copy of the counter affidavit, but
Anyway, we will reject LPA. It is a frivolous and matterless to tribal issue.
annexure C ये अथी ये annexure C, kindly peruse annexure C at page 20, your lordship. A detailment of promotion cadre course from HC and head constable to ASI.
You are promoted.
Head constable, now I am going to do the promotional course.
Sir, the allegation is when you are a constable, head constable. What is the date of head constable promotion?
Good. 7/1/21 with effect from 7/1/21.
By that time, single judge order was there.
Order
was there.
18.
Huh?
18.
18. That is the reason he has been promoted.
But
Now you wanted to take away the benefits by virtue of filing LPA.
no, we have already filed the LPA in the year 2018, Your Lordship.
Yes, take on. In the instant LPA, appellant has assigned the appellant dash Union of India has assigned the order of the learned single judge dated 4th April 2018. Passed in CWJC 3032 of 2017. So the facts of the case are respondent Balasius Lakhara.
Bilkis Lakra.
Balasius Lakhara was admitted to hospital for taking certain treatments during the intervening period from 2/7/2016 to 11/7/2016. As is evident from the records. Here, sir. On 8/8/2016, during the inspection, the officials noticed that the petitioner was sleeping in the watchtower while leaving the rifle on his side. Yes, sir. On this alleged allegation, show cause notice was issued for imposition of minor penalties under CISF Rules 2001. While invoking Rule 37, thereafter proceeded to impose the penalty of withholding of pay for 3 days. And further, in appeal, it was modified to the extent that withholding of pay for a period of 2 days. So, feeling aggrieved and dissatisfied with the punishment, the respondent had invoked a remedy before this filing a writ petition CWJC 3032 of 2017. And it was decided on 4/4/2019, hence the present LPA. So, when counsel for the appellant submitted that observation of the learned single judge incorrect. So, the appellant are agreed by the observation made by the learned single judge namely within inverted comma. Now the only question is with regard to quantum of punishment, comma, which in my considered view is not required to be interpreted with, comma. However, the present fact and circumstances of the case as well as the principle of equity requires issuance of a direction to the effect that the said order of the punishment shall not be considered a stigma on the petitioner herein and would not create any impediment in the future promotional prospects. Invited comma close. Submitted that the above observation would affect department would affect the department to the extent that a respondent was punished, and if it is taken into consideration for the purpose of promotion, the promotion would be deferred. Therefore, the aforementioned observation is to be set aside so as to give effect to the punishment while considering his name for promotion and defer the date of promotion. To the step. It is also submitted that having regard to the alleged allegations leveled against the respondent, imposition of punishment and its modification is in order. And further, in not giving effect to or being a hurdle for promotion cannot be taken away to the stop. Per contra, and counsel for the respondent resisted the aforesaid contention and submitted that during pendency of the LPA, he has been promoted to the post of head constable on 7/1/2021, and further he has been promoted to the ASI.
Going to do the course of ASI, promotional course.
And he is likely to be promoted to the post of assistant sub-inspector, and his name is under consideration. Good stuff. It is also submitted that disciplinary authority has taken note of medical events. However, the disciplinary authority is of the view that in the event of a respondent suffering from certain illness, instead of attending work, he should have availed the leave. At the same time, disciplinary authority has not apprised that respondent had orally requested his immediate superior for availing leave, and it was ignored by his immediate superior, which has resulted in the allegation of respondent was sleeping at the time of inspection by his superiors. So, no doubt, constable who has been deployed in a watch tower should be alert in watching the territorial jurisdiction which are visible to him. on the other hand sleeping during a deployment in a tower is a serious misconduct. At the same time, one cannot ignore that it is beyond the control of the respondent for the reasons that his immediate superior failed to understand the feelings of the respondent at that relevant point of time or a moment that he was suffering from certain illness. So, taking into all these issues and the fact that the respondent has already promoted to the post of a constable and he is expecting further promotion to the post of assistant sub inspector. Therefore, it is not appropriate to interfere with the